We'd like to begin the enforcement committee meetings. If you guys can take your seats, please. One more?
With authority.
Oh, okay. I thought you wanted a double gavel.
Double guy.
Welcome to the Enforcement Committee meeting. Our first agenda item is a call to order and establishment of quorum. Mark, if you could do us the honors.
Hildy Aguinaldo.
Present.
Francisco Shea.
Here.
Jeannie Kang.
Present.
Jamie Zamora. Here. We have a quorum, Hildy.
Wonderful. Thank you very much. Our second agenda item is discussion and possible action of revised disciplinary guidelines. Christine and Mark, if you could take that away.
Okay. This basically the memo is obviously very comprehensive and covers the changes. So I think what we'll do is we'll just kind of just quickly recap what we've been doing, and we can start to take questions about the document itself, whatever, however you'd like to do it, Hildy. But however you want to do it. Basically, our guidelines have been in place. Our present guidelines have been in regulation since 1996. It is the document that we utilize to, it's used by attorneys, ALJs, et cetera, in anyone involved in the disciplinary process. And, that's almost 20 years old, or it is 20 years old. So we need to update it. This is something that I know, Hildy, you have expressed interest in getting going, and other board members have. And so we've sort of had this issue on our radar for several years. Originally, back around 2011, we had started a revision of the guidelines along with combining the uniform standards for disciplinary guidelines for substance abusing licensees. We had originally attempted to combine those together. At Kelsey's suggestion, we separated out the uniform standards to a separate regulatory package, and staff began working on these guidelines around October. It's been a lot of work, and it's good to sort of have something in place for you guys to look at. It's a pretty comprehensive overhaul of our guidelines. There's a lot of stuff in there that we left in that has been working for us, but we also added in a number of things that are new that have worked for other boards or have worked as sort of in our experience, and we sort of put them into the guidelines themselves. So really, that's kind of just an overview of it. I think, however you want to go through the changes, Hildy, we can begin to do that, but that's kind of the overview.
Absolutely. I defer to you and Christine on the specific method of how you want to march through these individual disciplinary guidelines, but I'd like to thank you guys. It's obvious that a lot of work went into this for several years, so I really appreciate the level of detail and the utility of this document once it goes forward. For members of the public, there's an enormous amount of work that went into this. I hope you guys had the opportunity to read through it. So just before we jump into the substantive aspects of the report, Mark and Christina, if you could kind of go into the process of what went into revising these disciplinary guidelines. What kind of input did you get, and exactly what kind of things did you consider in making sure that this was comprehensive and really captured everything that we've needed to put in there in the last 20 years?
Well, we started out, researching other boards, looking at language that we thought was relevant to us and would work well. Also, just as enforcement staff, in using an outdated document, we're hindered. And so we kind of already had that in mind, what those obstacles were. We've even kind of, for our stipulated settlements, when we can have more discretion in developing language, we kind of, kept that and considered it for the use of this document. So, and Kelsey, obviously, she's given us good language from other boards that she's seen as well. So,
Wonderful. Let's jump right into the proposed changes then.
Oh, I just want to say one thing too. That these are guidelines, and when we had discussed what to include, what not to include, It's not obviously an exhaustive list, but based on what your enforcement staff sees as issues that arise and terms that would be used. So there, are other terms that could be added, but, if the perfect situation were to arise, but they weren't necessarily included because it's not something that, is seen often, and that's included. But I just wanna throw that out there,
And I also wanted to also comment on how well this was written. And I know the several staff worked on it, I think Mark and Christine. I really enjoyed reading it. So thank you for such a organized, thought streaming, your wording. It was really well done, and I really noticed it out of all the materials I've read over the years. It was really well done, so thank you.
Thanks, Gene.
A quick question, Mark. Once we complete this and review this today, what happens then?
That's dependent on, I
Just say
think.
we approve them.
Yeah, we can, it's at your discretion, but we can make the changes. If you request any, we can change, and then we can report this to the full board at the next board meeting for review. But it's up to the committee.
Kelsey, how would that work? Would we make the recommendation to the full board to adopt the changes that we foreseeably make today? And then would that full board meeting be the one coming up after this meeting, or would it be the next regularly noticed full board meeting?
So the way that it works is that you do have, let me just make sure. There are a couple options. Here's your full agenda, sorry.
Is it the red one? The red tab?
It is, thank you. You do have, an update and possible action on committee reports. So as a committee, if you feel that the language is ready to go, you can go ahead and recommend to the full board to approve it and then have staff, put it out for a 45-day notice. If you do not feel that it's ready to go, if you want to refer it back to staff to make any necessary changes, or if you just don't feel like it's ready, your recommendation can be that the board take it up at to basically you would refer it back to staff to work on it and then bring it at a future agenda
So we
meeting
did
to a full
application.
board.
And this is also one of the reasons why, even though you're not on the committee as a board member, you should read all of the materials, because you will be evaluating it at the full board level at some point. So I hope all the board members who aren't sitting on the committee
right.
actually has the opportunity to read the very exhaustive memo and revised disciplinary guidelines for consideration later on.
So ideally for staff, we're probably gonna, if we had any changes, to let you go back and make the changes before.
It might be a little bit easier, and then,
Bring it back for you.
I mean, at least they're minor and technical.
Unless you guys can get on the laptop in the corner.
Yeah. Just one last question. I apologize. I keep popcorning you with questions before we jump into the substance of this. What is the availability of these disciplinary guidelines to the public? Is this something that's posted online?
It will be. So right now you have your 1996 guidelines that are posted online. Any changes, all this new changes, it goes through the regulation process. So it will be put out for a 45-day comment period. It will be posted on the board's website, and it will go through that same availability to the public as any other regulation is.
Wonderful.
Ben, I'm not sure, but is this one of the items from the strategic plan?
Yes, I do believe so.
Okay, so this is something the legislature had been
Yeah.
looking at. Okay, great. Good job.
Wonderful.
We're on track.
We're on track.
Let's get into it.
Okay. So I'll just kind of go over each change. So obviously, we're just updating the cover page and just condensed it to disciplinary.
The language.
Oh, yeah, let's start there. Okay. So it's a regulatory change. This document that we're making changes to is incorporated by reference in the regulation. So the actual regulatory language, it's just a small update where we're adding a revision date. Right now it's December 2016. We struck through Department of Consumer Affairs because this proposed document is just titled Acupuncture Board Disciplinary Guidelines.
revised December 2016.
Yeah, revised. So the actual document itself, like I said, just updating the cover page, making it more
Consistent.
nicer in appearance and everything. Yeah. Added a table of contents. Easier on the reader to find things. We updated the introduction. We added more language explaining the different conditions that you'll see, probationary conditions, and more direction to the users of the document, administrative law judges, attorneys, respondents.
It's probably just important to note from a sort of a global perspective throughout the entire document, we wanted to make an effort to, obviously, the board is no longer referred to as the Acupuncture Committee, which is AC throughout the documents. So we replaced all that throughout the documents, now the board. We just wanted to sort of clean up, make the text uniform, just sort of make it more readable, because the 96 guidelines was sort of a jumble of stuff.
Different fonts, yeah.
Yeah, so that was sort of improved the
Yeah.
overall readability as well.
Yeah. So I'll just continue on. Please stop me if you have any changes or questions, comments. We added a section titled General Considerations, things to take under consideration, factors when imposing revocation, suspension, or probation. Then we go into the section of terms and conditions. There was already language laying out the different optional terms and conditions, standard terms and conditions. We added a third category consisting of special conditions due to new regulatory law changes. If a licensee is deemed to be a substance abusing licensee, then we're directing them to refer to the document Uniform Standards Related to Substance Abusing Licensees. And if someone is a registered sex offender, there is only one penalty, or I should say there's three, but if you're licensed, it's to be revoked. If you're an applicant, it's to be denied a license. And then also to deny any petition for reinstatement. So there's not like a range of penalty options, it's just that. So that's laid out. We added a table of optional terms and conditions and standard terms and conditions for quick reference. And then going forward, we made some changes to the psychological evaluation. Number two, condition, yeah, optional condition number 2. And I'm just gonna go to my notes.
You're referring to the number 2 psychological evaluation, page 17?
Page 7, yeah.
Okay. I had a question on that, actually.
Yeah.
I remember from some of our previous discussions on the board that we were intentional in leaving the references in. We wanted to make sure that we were referring to a particular DSM or particular documents. We can't just leave it vague. We actually have to put the specific year, edition. So is it possible for us to remove the DSM reference so that we're not held to a specific one?
That's basically what we proposed, but I don't know, Kelsey, can we do that?
So,
We didn't
no,
put a
it will
specific
need to,
edition.
because the reader, those that are affected by the regulation have to be able to understand at every point what is being required of them. So it does need to be specific. So that was an oversight on my part, but they can't receive a current diagnostic and statistical manual of mental disorders. It's gonna have to be a specific one. So,
Okay.
So
So
where it
add
says
the latest
the
edition.
prior third edition has been struck through, so the condition is not held to a specific DSM edition, we have to actually put DSM 3 or 4, whatever we're on now. Okay. Which one are we on now? Does anyone know?
I'd have to go with one.
5?
5?
Yeah, I remember us talking about this quite extensively, so I think we're gonna need to check whether it's 5 or 6 or 2 or whatever it is, but we should check on that.
So
And
you
I
want to
think,
strike the word, current?
Well, that was already in place, but it's existing language.
yeah, the boarders designee shall receive a current diagnostic and statistical manual of mental disorders, parentheses DSM 5 or whatever the current one is, diagnosis.
Does anybody else have any other changes or
No,
comments?
I
to
think
that?
it's good, the changes are good. I think they should pay for it.
Okay. Moving on. Just a slight change with condition number 3, physical examination. Just added that failure to pay the cost will be considered a violation of the probation order. Number 4, we added practice billing monitor. We added that the condition will also apply to having a billing monitor. So we struck through the existing language for practice monitor, although some of the how the actual condition operates is retained. It's just the language is kind of moved around some. But it allows for it to be done for practice or billing monitor or both. And another big change was respondents are required to make all records available for immediate inspection and copying on the premises by the board. That was not in place beforehand. Let's see, what else did I say here? We added more detail on the role of the board reviewing the monitoring plan to provide more instruction. We struck the language regarding specific frequency of meetings with the monitor. Existing language says it's at least 1 hour per week face-to-face meetings. But, you know, we kind of want that chance to change it on a case-by-case basis. So left it up to be determined by the board or its designee. Then there was additional language added to the part of the condition that addresses when a monitor resigns or is no longer available. So we would have the mechanics of how that would work. And that was basically it for that. Any changes? Okay. We added a new condition, number 5, psychotherapy. This can either be in order in place along with a psychological evaluation, and it further defines how if after psychological evaluation, if they deem that the respondent should go through psychotherapy, sort of how that would operate and our oversight of that, or it can be a standalone condition that the respondent undergoes psychotherapy. Moving on, their existing guidelines had restrictions of patient population, and we're amending it to be restrictions on patient population or practice setting. So, and also our existing guidelines didn't have actual specific language. So we're adding specific language to make restrictions on the patient population or a practice setting, like if we wanted somebody to not be in a solo practice, they needed to be in a group practice, or if they are restricted to not practice on female patients. So that allows us putting that in place. And then we added another condition, number 7, restrictions on practice techniques and modalities. If there's a case involving neglect, negligence, or incompetence in a certain area of their practice, maybe involving herbs or moxibustion, then we could prohibit them from providing that specific modality during the probation period. Number 8, that condition for examinations, we just updated it because current language had a section about them having to pass the clinical portion of the exam, which we no longer do. And then also we updated it to, since we're having a change in our exam, that they just would have to pass the exam that's required for licensure. And then also we're requiring them to pass the exam within the first 12 months of their probation, or it would be considered a violation of probation. Let's see. Restitution. We didn't really make any changes to restitution. Condition number 10, alcohol and drug abuse treatment program. Beforehand, we used to, or the language sort of addressed the treatment program, and it was like a two-part condition. It addressed the treatment program that they were to enroll in, and then also like follow-up 12-step or group therapy, and we felt that it was best if we separated it out. So this condition was amended to just address a treatment program, and we took the minimum duration from 6 months to 3 months, just to kind of bring in line and what we see when we see like DUIs. The first offender program is typically 3 months minimum. And, but also that we could consider recovery programs taken under a court order within the last 3 years prior to the effective date. Let's see. And then just the mechanics of how they would submit the proof of their completion of the recovery program.
So Christine, I have two questions. One to back up to number 8, examinations, and then I have
Sure.
another one on number 10. So I'll do the number 10 one because we're there right now. Anytime there's a reference to days, something needs to be submitted within 10 days or 15 days. Does that mean it needs to be put in the mail? Does it mean it needs to be received by the board office in 15 days? What does that mean?
It typically means that we have to have receipt of it within that 15 days. So on the 15-day mark, it needs to be in our office.
Is there a way that we can clarify that so that, you know, in the legal profession, there's a huge difference between served and received and filed. And
Right.
we need to make sure that it's as clear as possible. Number 8 on examinations, I'm looking both at the memorandum, page 4, and both the disciplinary actions, page 11. It says, if the respondent has not taken and passed the examination within 12 months from the effective date of this decision, respondent shall be considered to be in violation of probation. So does that mean after a student graduates, they're put in a probationary period and they have 12 months to pass the exam? Otherwise, what does that mean?
No, this is just if you're requiring an examination for someone who has been disciplined. So let's say you have somebody that's disciplined and you're gonna put them on a really long probation, and they're gonna be really limited in practice. You may want them to, or you may just think that, or maybe they have negligence, something like that. So you may want them, you think, okay, well, if we're gonna give them a full license again, we want them to take the examination and pass it again. So it's not necessarily applying to students, it's applying to somebody who
Has
the
previously been
board-
disciplined?
Yes, the
Okay.
board finds that, because, or it would be for, if you've revoked somebody's license and they've petitioned for reinstatement of their license, and the board says, okay, we think that, yes, you know, you've had your license revoked for 10 years, and now you come back and you have all this rehabilitation, and we're okay, we're gonna reactivate your license, but you need to pass the examination again because you haven't been practicing for 10 years. So, or it happens in tolling situations where somebody has told they've been on probation, but they've told because they've gone out of state. So they haven't been practicing in-state in California for however many years, and they come back and their probation's about to be over. And we say, well, you need to take the examination in order to practice, to have a full license again. So that's the situations where the examination would come into place.
Thank you for the clarification. Very helpful.
Regarding section 10, the new section 10, did you want to use received by
Yeah.
within 15 days?
Received by the CAB office within 15 days.
Okay.
Yeah,
Receive it.
yeah.
Okay.
And then there are several references to dates to times as well. So if you could just take an extra look at other areas in the guidelines that require receipt by a certain amount of days.
Will do.
We can do that.
Thank you.
Okay.
Number 10.
Okay, number 10, reimbursement for probation surveillance monitoring, that was struck through, however, we've just made it a new standard condition. So this, in the existing guidelines, it's an optional condition, but we've just moved it to the standard terms and conditions. So we'll get to that later, what that is. Condition number 11, that's a new proposed condition, attend chemical dependency support and recovery groups. So as I was saying, this is sort of taking out the portion that was in the alcohol and drug abuse treatment condition about support and recovery groups and putting it as a standalone condition. And it's just more clear that way. Condition 12, abstain from drugs and alcohol and submit to tests and samples. We made, this is an existing condition that we made some changes to, kind of rephrased it a little bit and added in that they must completely abstain from associated paraphernalia except when the drugs are lawfully prescribed by a licensed practitioner as part of a documented medical treatment. So previously, we didn't have an exception for when respondents are on prescription drugs. This allows for that.
And this is another instance where we have to reinsert the BPC section?
No, I don't think so. I mean, we could. I guess, yeah, you're right, for dangerous drugs, we should.
For dangerous drugs.
Mhm.
So restore. What about controlled substances from the California Uniform, I guess, Health and Safety Code? We don't need
Yeah,
to
we could, yeah.
just restore that. And I don't know if these are the updated sections.
Yeah, we'd have to look at the.
Okay.
updated.
Okay. We also just added some more language about respondent actually providing documentation from the licensed practitioner about the prescription drugs for us to review and have that. And that's pretty much it for that condition there. Oh, yes. In the note section underneath, we added and directed, ALJs and attorneys to, if somebody is a substance abusing licensee, to refer to this document, uniform standards related to substance abusing licensees, because there are uniform standards that they would have to use for that particular respondent, and not these that we have in our guidelines. Condition 13, coursework, that's an existing condition we're amending. We're taking out the unit value of not less than 20 semester units or 30 quarter units. I would say out of all of the existing conditions in the guidelines, this is the most complicated, I guess. It causes the most problems for enforcement staff during probation because this is so many classes, and a lot of times we'll see it just be in a specific area, let's say just ethics. And it's like, how many courses can you take on ethics? Like, it's just so much. So it was difficult for our respondents, even on staff, to try and research and find different courses to apply for ethics, because schools really offer like maybe 1 or 2 courses on ethics, and then just any other areas. It's kind of a lot. So we did take it down, and we also well, it's actually, I'm sorry, we didn't take it down. We are making it to the board or its designee's discretion of determining how many hours based on the case.
And if I may jump in, Christine, just
Yeah.
to give you an idea, members, so 1 unit is equal to 15 hours. So we're looking at 300 hours originally of education. And that can take some time to complete, let alone, like Christine was saying, finding 300 hours worth of courses.
And it looks like from one of the previous committees, we were just talking about 4 hours of CE and professional ethics every 2 years. This just sounds like a lot.
Yeah, and they are not allowed to use any coursework that they do during their probation for their renewal. So it's like in addition to the 50 hours that they would have to do for renewal. So it's quite a bit. The other change was the existing guidelines state that it had to be at a graduate level at a school approved by the board. We have taken it to, it can be coursework in continuing education or equivalent. So that kind of allows them to take it from either one.
And then if I can just, I think there's just maybe a typo here.
Oh.
That respondent should take and successfully complete, and then it should be, there should be like an, it should just be an underline right there.
Where's this at?
The very
Complete
first line.
Underline
Oh,
coursework,
respondent shall take and successfully complete.
complete underline.
Because aren't you gonna set how many, wouldn't it be an individual basis, you'd set how many CE courses they need to take? Or is it just one?
Oh, so we would need a blank underline section to
Yeah.
show that we
It's
fill in the
crossed out.
variable, right?
Yes,
Got
it's
it.
crossed out
Yeah.
right now, so I think it's just, it's,
Include that.
Yeah.
Include the underline.
X equals.
I'm still not, because I want to make sure that it's,
so where it says not less than 20
Yeah,
election
yeah.
units
Mhm.
or 30, so we've taken out all units there, so,
Complete underline coursework.
okay,
right?
yeah.
Because that's what's gonna be filled in. Is that right?
Well, are you saying that we need to then put a unit or hour value here? Is that what you're saying?
No, just a place to list how
Just
many.
underline.
Oh, an underline for us to determine?
Yeah.
I see.
Complete
Yeah.
To
Underline,
assign.
underline, fill in the blank coursework.
No?
The problem with that, when we were looking at that, was then, let's say it's a proposed decision, and ALJ is going to plug in a number there if it's a blank.
Right.
We were thinking that they determine that the coursework is required, but staff determines the coursework, how many hours, and what's relevant to the violation, the coursework area, staff, and the executive officer.
Okay,
So it's like open-ended,
okay.
That
so
would-
it can be determined on a
then-
case-by-case basis.
Wouldn't that have been communicated with the DAG before it even reaches the ALJ? Like, the ALJ is already looking at kind of sort of a draft order, right?
Well-
You're saying if we put a blank there, the ALJ would fill it in, even though the ALJ is not familiar with
No, the
what is
ALJ
needed.
does fill it in.
Yeah.
When it is a proposed decision, when the ALJ has the hearing, it's not, the ALJ determines which ones apply. The DAG can make a recommendation, but the ALJ will determine which, what applies. And like, for example, your very first one is suspension, the very first term. In that case, the ALJ would say, okay, I think you need to be suspended, actually suspended for 5 days, and they would insert that in.
So how do we make it so that the staff has an opportunity to recommend to the, should be, 5 units, 10 units?
So,
That's what we were trying to achieve here.
yeah, and I don't
General.
necessarily know that the language here allows that, because what it's saying now is that you're just gonna approve basically the coursework, and it's not saying the number. It's not saying the.
I see what you're saying.
The board will set the number, the board or
Right.
its designee.
I
And
see what you're saying.
I think that if you're requiring, I think that is something that the ALJ is just gonna have to plug in,
Yeah.
unless you, yeah.
Could we create a note about
You could create a note,
Okay.
at the bottom,
Okay.
with different,
Can we
and
say?
because the board would then
ideas.
have the discretion, what would happen if, let's say the ALJ plugged in something ridiculous, and I don't necessarily know what that number would be, because I don't do enforcement, but let's just say they said, oh, you have to do 100 courses. And the board then, the board has to approve ALJ decisions, and the board says, whoa, that's very ridiculous. We don't think that that warrants this. So then the board would be able to reject that decision and different term.
Or could we say the ALJ upon recommendation of the board or its designee?
No, because the ALJ is given discretion. The ALJ is setting the terms, and then the board either adopts the decision or does not adopt the
The
decision.
ALJ upon consideration of,
So the ALJ, that's
Suggestion.
no, because that's gonna be, that's impermissible communication.
so there's really limited
So
ways of getting around
it is,
this.
because the board is delegating to the ALJ to handle the hearing, and the ALJ is taking all the evidence and weighing all that evidence and applying certain weight to that evidence, then the ALJ is given that discretion to set the terms and say which optional terms apply and which ones don't. This is a guideline to say, here, ALJ, in these types of situations, you should apply this, you should apply that. Now, if it's a stipulated agreement, then your board staff does have that discretion to say, and to work with the respondent in order to set that based on that specific situation. But when it is delegated to an ALJ, they do have a certain discretion. And so you want to make it a document where they can just plug it in based on what you want. But then again, the board has that fallback of being able to reject the decision. So
I think that's why the range was in there in the first place, right? Maybe we just need to revise the range.
We could do that.
Or you could, like Mark suggested, put a note that it be, based specific on the facts and.
Right. Could you just say in here that as a separate sentence, coursework area and total number of hours are approved or determined by the board or its designee? So then it still allows staff to, but it is more specific in what we are able to determine.
Probably do some research on what other boards maybe do.
I think we kind of did.
I thought when we get proposed decisions, all that stuff is at the very end of the decision, or not.
It is,
not
so the
decision,
terms and the
yeah.
conditions are already set.
Yeah.
There are certain
Hands are tied.
things like, that are delegated to the designee, like your quarterly reports and things like that nature, but I think the actual terms of what you're required to do needs to be in the order.
But that's based upon the negotiation between the DAG and the staff.
No, that's
Or
in a stipulated agreement.
The attorney and the DAG.
It's based on the
The ALJ makes
evidence.
a decision based on the
of the
evidence.
hearing.
So the DAG represents the state of California.
Right.
And if the responding to the rep is there on their own, or they can be represented as well, they both come before. But the DAG is not representing the board in that matter. The DAG is representing the people of California.
So there is no opportunity for the staff to go in there and say, we would recommend this many units of professional ethics and law, or whatever was discussed at the last board meeting.
And we also wanted to distinguish between units and hours, because you have continuing education units, but then you also have academic units, so we wanted to just take that out and leave it at hours.
I mean, is this something where perhaps, going back in line to one of the earlier questions we asked, maybe we should discuss this further, and before we bring this back to the full board, we would have figured this out?
I mean, I think you could probably do two things. You could have a range. You could say no more than, kind of like it was, but, or have a note that says,
But if we have a range, does the ALJ still have discretion, just?
yes,
signal?
absolutely.
Maybe the range should be an hourly range instead of a semester or quarter unit range.
Yeah.
Yeah, so that's what they're taking out, but, so now it is continuing education units. I'm making sure that I'm getting it right. So now it's going to be continuing education units, and so it's going to be a set number of units, but that does, when it does go to an ALJ, that does need to be in the order as to how many units, and then the board would have discretion upon adopting or rejecting the ALJ's decision to change those unit numbers, but I don't think you can just have it as the designee.
Okay.
But we could put hours instead of units.
You could put hours instead of units.
Well, I think when we were sort of coming up with this, at a previous board that staff has been at, they have a condition for an ethics course, and it just says, take an ethics course as, you know, approved or determined by the board or its designee. So then staff was then saying, okay, well, maybe they should take 5 hours in ethics at that point. So it was kind of like working the same way.
Right, but it's still one course. So
Yeah,
you
it was
have to
only
take
one course, yeah.
And so that's very specific, and
Yeah.
then the board or its designee can determine which courses are approved.
Okay,
So again, here it's the same thing, because the board or
broad.
its designee is approving which ones are going to satisfy this requirement.
right,
But the requirement itself needs to be clear
Got it.
in the order.
okay.
But again, when you have STIPs, when you have those types of things, that's not gonna be an issue for your staff. But when it goes to an ALJ, it is.
So maybe a range, yeah.
I'm in favor of an hourly range. I think that's the best way to get around this.
Okay.
And if there's a clarifying note that needs to be stated at the bottom, then let's do it. Because as you said, this is a tool for the ALJs as well, and we need to make it as useful to them as it is to us.
Do you guys want to discuss an actual range setting it now, or do you want us to just come up with something and then bring it at a later date?
I mean, I have no pre-existing knowledge base in the hours of ethics required, nor do
Or
I
other,
have-
it's gonna be
right.
other areas too,
Yeah,
yeah.
it's not specific, it's just ethics.
So if there was, if we could do the same where we kind of take into consideration what other boards have done and then customize it to our needs, then I think we would appreciate a recommendation from you, because I am in no position to give you a recommendation as to the hours necessary. And then that section, also 13 coursework, also has a 15 days of completion in the third line in the memorandum. If we could also clarify that to say, to be received by the board office within 15 days of completion.
Okay.
We'll go through the entire document and make sure we note that everywhere.
And Kelsey, do you think it's necessary to say received by certified mail or received by email, or, you know, I don't know if people are
So I don't know
emailing this.
I mean, that's kind of a good question for Christine, because she's a probation monitor, so, I don't, you know, I don't know how necessarily.
Yeah, sometimes we do allow certain things to be submitted online or by fax, but I would probably not specify that, because there are some times where we want it, you know, actual, like, the original of the certificate, or not the original, but a copy mailed in of the certificate.
Should we request by certified mail unless otherwise directed by CABRA's its designee? Like, if somebody sent it in and you say, well, you can go ahead and fax it just so that we have it sooner than later, then they can go ahead and fax it. But I think we should specify in there, don't email your completion certificate to us at whatever what's our email address, like
Acupuncture at DCA.
acupuncture@dca.ca.gov. Like, don't email us your certificates of completion. It should be by
Could
certified
that
mail.
actually be a standard term and a condition? Can we add that in as a standard term and condition?
We do a lot of communication with our probationers through email. It's a very good tool for
No,
us.
I'm just saying
They're not
what she's
submitting.
talking about in terms
Yeah.
of submitting by calendar date, whatever. I mean, could we add that as a term and condition? Make it, I don't know, or make it, I don't know.
If you guys want to.
I mean, we're leaving it open so that unless otherwise directed by staff.
Yeah.
But then you're putting the onus on your staff to make sure that they communicate
That all the
in
time.
writing every time when they're making an exception.
Yeah.
By certified mail. I mean, I just, the way I'm reading this, if I'm a practitioner and I have to submit a certificate of completion, I'll just email it to you. And then hope that somebody reads the email docs. If we do it by certified mail, it's marked as received, it's just clearer. Especially on enforcement cases, you want to be as clear as possible. So I would suggest, you know, by certified mail on every single thing that requires a date. Because we do the same for our disciplinary actions, right? When we
Right.
serve them by certified mail.
Right.
And we can also look at other boards and see how they put that in code as well.
To my knowledge, I haven't seen any language like that. But it's not to say that you couldn't have it. But I don't know how it works in
Yeah.
practicality, so that's why I'm deferring it to Christine, because you don't wanna put too much work on your enforcement stuff that they're having to also, enforce this every time across the board when
Right.
they're also trying to help their probationers and also not trying to have probation be overly costly, and things like that. So I will defer to you to,
The other consideration is like, are we gonna view that as a violation of probation if they don't send it by certified mail, but we did get it by mail, that kind of
well, it
thing?
would, if you make it a term, then it is gonna be a
Yeah.
violation of probation if they don't do it.
And we have to address every violation we come across.
And then
So,
if you defer to that unless the board or its designee, waives that, then again, you're putting it back on the board staff every time to waive it in a situation. And I don't know how often you would waive it, or how often you would not waive it. So that's maybe something you can speak to a little bit.
there have been times that we've had probationers email documents, but I think they usually follow up by mail too, but, we're just looking for compliance and it's a copy regardless. And like I said, I have a lot of communication with my probationers through email. I think it's convenient, but there also are probationers who don't, don't choose to use email. It's, yeah, so we speak by phone or it's all by mail.
But when they're submitting things to you that are critical, I think that's probably not gonna be done over email. I mean, the correspondence you will have over email is like, don't forget to show up to X, or don't forget that this proceeding is coming down, you have to take care of these things, where they have an obligation to supply you with certain documents and information. It should be done more formally, but again, defer to you, you're the one touching this every day.
So maybe you could
Yeah.
go back and think about which items, which terms would require that sort of scrutiny and that level
Okay.
of, maybe that would be a good way to do it. And then Christine can come back and say, in these instances, this is when I would, this is when I wouldn't, and then maybe she can put it into the certain ones, like coursework. Maybe for CEs, you would want it by certified mail, so you would put that in this one, but
Right.
maybe it wouldn't be as big of a deal for community service. I don't know.
Yeah.
So, for the next term, so I don't know, but,
Right, because I mean, we have things that they have to submit that's just like a written plan, and it's like, well, it's written in by email, we can have that
Right.
communicated by email.
Yeah.
So,
and do you go back and forth, like, on, like, for example,
Yeah.
billing monitor? I can't remember which language we went with, but was it one or two? In terms of how many options they have to provide at the board.
for the monitoring
Mhm.
plan?
So let's say, for example, your first monitor didn't work out, for whatever reason, the board decides that monitor didn't, is that something that you would go back and forth with, where you'd have, have
Just one or more.
communication? So, would you,
Yeah,
would that be an unnecessary, like, burden, or would it be helpful?
I tend to do, the more back and forth if this person doesn't have an actual, like, let's say they have, the person they want to use as their monitor has a complaint or something, and so they don't qualify, then I could just communicate that by email and say you need to submit, another proposal.
And how
So-
are they generally submit?
We have it different ways, some by email, some by mail. Usually during my orientation with my probationers, I encourage them to use email.
So it sounds
Because
like
that
you're-
line of communication is more frequent,
Right.
they're, so I can keep
Instantaneous.
tabs. Yeah,
Yeah, I think all this shows is that there are, as you guys have identified, documents and information that need to be communicated more formally, and others that can be done
Yeah.
by email, so you'll just have to take a look and see which ones you'll need.
Because I would think, like, for this one, for example, I would think that in terms of the communication between which courses that the board approves and are gonna be okay to complete this probation term could probably be done via email. Hey, I wanna take this course on this date, would this be okay? Yes or no? But then maybe in actually mailing in the completed certificates, you would want that done by certified mail. So maybe it would be kind of broken down into different areas.
But then we go back to the issue, if they don't submit it, that's a violation of probation.
yeah.
Right.
Just really harsh, so.
Yeah. I mean, we have different sort of escalations or how we remedy violations, something like that is more minor. So it might be a letter of education, and a warning.
Okay.
But yeah, if they're continually doing something like that, then yeah, it does, kicks it up a notch. Citation.
If you're continually providing things in extremely late, I think that's
Yeah.
kind of worthy of,
Yeah.
of
Definitely.
escalation. But if the first level is just, a warning, then so be it.
Yeah.
Sounds fine.
Okay. So we're at
We're at, community
exploring it being submitted, us receiving it by certified mail for the coursework.
We were gonna do conditions, see which ones needed that.
Which ones are applicable to have
Oh,
certified
okay.
mail.
Enforcement stuff.
Okay.
Yeah.
Okay, sounds
More
good.
work, yeah.
Okay. Okay, so I'll move on to condition number 14, community service. This is an existing term, but it didn't have any language, so we made it more specific and laid out the language. They're supposed to submit their proof of their community service hours on a quarterly basis. And they're required to complete their community service no later than 6 months prior to the completion of probation. And this does give the option of identifying the number of hours within the condition. So the ALJ would have that authority to put that in there. Or if it's a stipulated settlement, we could put that in there.
And this is another one that talks about the submission within 60 days. This would be a perfect example of something that doesn't need to be done by certified mail, so we'll just have to pick and choose.
Okay. Okay, so we added another condition, number 15, supervised practice. Mainly this is to address cases where we feel that when they're practicing on patients, they need that constant supervision. It could apply to cases where there was sexual misconduct, and so you would want that supervised practice. It could also apply to cases where of negligence or incompetence. And we identify that it's be another licensed acupuncturist, or if another licensed acupuncturist cannot be there supervising, they can request that it be a licensee from a different profession. This may be a little bit difficult since most acupuncturists work as a sole proprietor, but we're looking for public protection here, so I think looking forward as staff, it's going to be a lot of back and forth of them being able to figure this out within their existing employment, how to figure this out, but it's really, it would be very good protection provided by that. So we're moving to so Kelsey, you were talking about making any motions. Do we need to do that at all, or we're just identifying the changes?
It's at the committee's discretion if you want to make a motion onto the optional terms and basically everything we've gone to up to now, or if you want to continue going through the document. I know we've made some changes, but mostly it's been directed staff to make the changes. So it would just be, I would probably recommend it in situations where you've made a lot of changes to kind of accurately reflect that and make a motion now. But I think that since most of it is being delegated back to staff, we can continue working forward, but it's up to you.
I prefer to delegate it back to staff, and I'd love to hear your guys' input on this. Delegate it back to staff, and then once you've made the changes, we could take the revised version back to the full board for voting.
I'm just saying in terms of, do you want to break up motions by optional conditions, or do you want to just keep moving forward? I don't think you guys have made too many extensive changes that we need to really rehash it, so I think we can continue moving forward, but I just wanted to make sure that that was the committee's desire.
Right.
What we were trying to deliberate kind of before the committee started was, do we address this like the SB 1246 comments where we take every single one and comment after every single one, or do we kind of take a more global approach and kind of give it back?
I think what we're doing is fine what we're doing, because I think we need to be efficient with time considering we have this and another item plus the full board meeting, so.
Right.
And considering these issues sound non-controversial, it seems like we're moving pretty well through it. I think we could take a vote at the end.
Agreed.
Agreed.
Okay, so I'll just keep moving on. So we did not make, obviously throughout the document, we've made changes to the condition numbers. So a lot of our standard terms and conditions, we haven't made huge changes. Obey all laws, number 16. Beforehand, we identified the levels of the laws and regulations that they would be required to comply with on probation. Instead of doing that, because then we would have to have this long, extensive list based on Kelsey's advice, we just put respondent shall obey all laws. So that's the only change there. And when we have our first orientations with our probationers, that's when we really sort of drive home, it really is every single law at every single level. If you get a speeding ticket, you need to write that into us, because they may just think that it's, related to acupuncture. Condition 17, quarterly reports, we just added a statement: if the final probation report is not submitted to the board timely, then we can automatically extend the probation period until such time the final report is received. Condition number 18, surveillance program, just minor changes, updating the terminology. Not really a change. Okay. Jumping to condition number 20, changes of employment. We just specified that they need to actually provide the employment address. Condition 21, tolling for out-of-state practice residents. We added more detail to let our probationers know that if they just went on vacation for 2 weeks out of state, this isn't going to qualify as a trip that would, toll their probation. We do have a lot of our probationers that leave the state, maybe to go to China, for an extended period of time. So we wanted to put this kind of qualifying day if it's 30 days or more. So we did that, then that would be considered tolling the probation. We also specify that the condition doesn't apply to ordered suspension or non-practice in compliance with the probation order. They wouldn't be told it during those times. Condition 22, employment and supervision of trainees. We added, which we felt was really important, respondent shall not teach at any board-approved training program during the course of this probation. Currently, our guidelines, don't prohibit that. We do have a regulation in place that prohibits CE instructors, if they've been disciplined, that they cannot teach CE courses, but there wasn't anything addressing when teaching in an approved training program. So, I felt that was important. Condition 23, cost recovery. We allowed the respondent to make payments in installments. We sort of kind of already do that in practice because it's difficult for somebody to make one lump sum of a huge amount. So we just added that into the actual language. Added that cost recovery will not be tolled. So if they do leave the state to reside or practice, they're going to have to continue paying their costs. And if they were to file for bankruptcy, we added language that is not a dischargeable debt. They would still need to reimburse.
Can we do that? So, this is a controversial one. There is not very clear case law as to whether or not cost recovery for a disciplinary action is a dischargeable debt or not. There is case law that is suggestive that it might be, might not be, it might not be a dischargeable debt. And so boards have been putting this language in as a notice. Now, whether or not the bankruptcy judge would uphold that is a different story. but we have been putting it in as a notice to those that if we did go if somebody did file bankruptcy and we were a part of that, they couldn't say, well, I didn't know, at least we've given them notice. But whether or not it's dischargeable, and I don't pretend to be an expert on bankruptcy law, and I know that our office has asked the Attorney General for an opinion on it as well several times, different boards have. So in an abundance of caution, we have been putting these into disciplinary guidelines, just more as notice rather than an enforceable provision.
Okay. Because if we put it in and the bankruptcy judge doesn't agree with it, you know, so be it. But if we don't put it in, we lose entitlement to.
Right.
Right,
And
okay.
and I think the feeling was that in a couple cases where notice hadn't been given, it was kind of like, well, I didn't know that, this wasn't gonna be,
Dischargeable.
exactly. So at least it's there, at least that there's notice, and if we did have to go before the judge, we could say in good faith that we did give notice.
And then we drag ourselves also into bankruptcy cases, which is more work for you, so.
More staff.
If we could.
Yeah.
If we could also add, Christine, more specificity as to the title, because I see, number 25 is also a cost recovery, issue. There's also one on page 10 of the memorandum that's also talking about cost recovery. So if we just say
So-
cost recovery for investigation and enforcement in the title.
Yeah.
I think that would be helpful.
The statute actually does call it cost recovery, and then the other ones are different, like probation monitoring costs and stuff like that. But, yeah, I agree with making it totally specific.
Sure. Condition 24, violation of probation. We have amended the existing condition that would allow us continuing jurisdiction over respondent if they have any outstanding terms and conditions and they've reached the end of their probation. They would need to comply with those, and we could just extend the probation period. Condition 25, probation monitoring costs. This was the one that was it was an optional condition. We moved it to this standard terms and conditions. And actually, I'm not so sure if there was actual language before either, but
There was, but it
Oh,
was
yeah, there
very,
was.
It didn't look like that.
yeah.
Shall
Oh,
pay blank.
reimbursing hourly costs. Oh, yeah.
Shall
So
pay
we,
blank.
right, so it did read, respondent shall reimburse the board for the hourly costs it incurs in monitoring the probation to ensure compliance for the duration of the probation period. So we actually we kept it kind of the same. I need to probably update the
Which that one
crossing out.
might need to be updated a little bit. We can look at the different boards too. I
Ye-
know we
yeah.
did, but we have kind
We
of talked
did.
back and forth about that one.
Yeah.
Um,
After our discussion, we kind of spoke with Ben and we were like, okay, well, we should leave it general because we don't have a way of assessing the actual costs, except for when we have to travel to meet with them and conduct quarterly reviews.
Right.
So, but yeah,
Yeah, we can update.
Refine
this.
that.
Could we also, make the title parallel, so it would say cost recovery of probation monitoring?
So this is not technically cost recovery. So
Oh.
cost recovery is something, the term that's used for the statute is cost recovery is for, and it is something that can be ordered in the actual judgment. And so this is something separate, this is for probation monitoring costs. So it's not, cost recovery, when we talk about it in disciplinary cases, there's a specific statute in the Business and Professions Code, and it only applies to cost of investigation and enforcement. So it doesn't apply to the probation aspect of it. It's everything that happened prior, when the accusation was filed, prior to this decision being handled. So the ALJ orders it, and there's different factors that have to be weighed in order to determine cost recovery. So this is actually technically probation monitoring costs. It is not cost recovery.
This is just saying if there are costs incurred from probation monitoring, those costs are borne by the respondent.
Right.
Okay.
So, which there are, because you have a probation monitor that has to receive all this information and has to go back and forth and approve as the board's designee certain plans or certain monitors or certain, CE courses. So there are costs, but it's not something that's ordered in the judgment. It's something that the probationer is now, based on how long they're on probation, are going to have to pay.
Okay.
Condition 26, license surrender, a new optional condition that allows a respondent to basically surrender their license if they want to resign, or they just maybe can no longer satisfy the terms and conditions of the probation. This gives them the option to surrender. However, the surrender is done through a disciplinary action. And let's see, condition 27, severability clause. This just states that each condition of probation is a separate and distinct condition. So if they cannot, if something is declared unenforceable, then the remainder of the decision and order shall not be affected. Condition 28, notification of name, address, telephone number, or email address changes. We just added this so probation monitors can get the most current contact information. Maintenance of valid license, condition 29, this was added to require the probationer to maintain an active and current license during the time that they're on probation. And that completes that for the standard conditions. Penalty guidelines. So we basically struck through the entire, I'm moving on too quickly. The existing disciplinary guidelines, the way that they laid it out was they laid it out the violations by examples and didn't actually tie it to the statute that it was violating, and felt that that was kind of confusing and limiting. So that was all struck through. It also didn't really address some general provisions that we come across a lot, like sexual misconduct. So we added a general provision section, and we just only used some of the more general violations that we see. So there's an advertising one, sexual misconduct, section 76, and then we outline the maximum and minimum penalties there, and then we identify what optional conditions are being recommended to be put into a disciplinary order or probation order.
The revisions are a lot more useful than the old version.
Yes.
I
Okay.
think this is a little
As your
embarrassing.
attorney as well, if I'm going through a decision, looking at something and I'm like, oh, what, I gotta look at an example to figure out what the minimum penalty should be, so
Right.
I'm sure ALJs, are gonna like this, and
Yeah.
I will like this. Board members will like it.
Much cleaner.
Yes.
Better representative.
So sort of like a wholesale change that we did was if you look at the prior penalties, it was the minimum was 5 years. So we have the minimum penalty that we're proposing is 3 years, and this is kind of just based on what you see with other boards, and also just what we've been seeing with decision and orders that you guys have been adopting, our stipulated settlements and things. I won't go specifically like what actual conditions we're applying to each penalty. So any questions there or comments on that whole section?
I don't have any other questions on the rest of the document. Do you guys have any?
Oh, okay, then.
Well, not to cut you off, but if you wanna,
No, because I know time is, an
Yeah.
issue, so.
Maybe we should cover just a couple of the new language. that's
Shall we,
that's all new stuff we should probably-
take public comment?
Well, it's just one.
How do you,
Do you have a motion that's,
What would the motion sound like?
The motion would be to delegate back to staff to make the updated changes that were discussed and to, like, throughout the document, and then bring it back to the board at a later date.
Let's do that. Do I have a motion?
You make-
I move to,
I was making motions.
I move to ask the staff to make the changes that we discussed, and following completion of those changes, to take the revised version to the full board for discussion and possible adoption.
Second.
Any board comment? Any public comment?
Good job, guys. Thank you, everyone.
I can now officially say good afternoon. Steve Given, Associate Dean, CIIS. These are minor questions/comments. On page 9, number 4, so it's the second page of number 4, the paragraph that begins with 90 calendar days. There are, I think the requirements, qualifications for the monitor is clear, except for duration of practice of the monitor is not specified. Would the board accept a new licensee in that uncomfortable position? So the board and ACOM both require 5 years for clinic supervisor, so something to consider if you are considering something. If this is standard language and nothing can be considered, then that is understood. But I just wanted to point out that it does not appear to be.
So we're looking at two different documents. One is the memorandum, the other one is actually the disciplinary guidelines with the strike-throughs and the underlines. Are you looking at the?
Oh, sorry,
disciplinary guidelines?
I have just the underlines and strike-throughs.
Okay, so that's probably the
Page 9.
disciplinary
It's
guidelines,
page
page
9.
9.
Yeah.
Which paragraph are you looking at?
I'm at the top of page 9, within 90
Within 90
calendar days. I apologize. I didn't realize there was another document. So it just, duration of practice is the question. And I'm pointing out that you already have a standard of 5 years. And that's all there. On page 13, you have, I think quite appropriately, I commend and support the inclusion of chemical dependency support group, such as AA or NA. If that is possible, I would suggest that you specify 12-step if you're able to do that. I understand that level of specificity may not be possible. The alternatives are generally not terribly useful, and so 12-step is. The other thing is you don't specify duration of participation. When I worked in court-ordered, as a provider in court-ordered drug treatment programs, they would specify some level of participation, a year or 6 months, and or you run the risk of having somebody show up with 1 sign-off or 2 sign-offs and calling that, meeting that requirement. Also on page 13, this is really small wordsmithing. I think you're intending the licensed provider. Practitioner often includes things such as DCs, NDs, and acupuncturist, and licensed medical provider might be clearer there. This is the 1, 2, 3, 4, 5, 6 line from the bottom, documentation from the licensed medical provider. It's a very small suggestion to clarify that we're looking at someone with prescription rights in Western medicine. I think you've already discussed that concern, so I could run away from that. Again, on number 15, which would be on page 15, the qualification of the monitor is the issue. And thank you so much for considering these questions.
Thank you very much for bringing your laptop up here and providing real-time feedback on what's going on. Should we,
So you can address that, and I think
Address.
it's, so I think the supervised practice, the qualifications could be put in. I think that the board or its designee has to approve the supervisor. So it could be done on the back end that way, by saying you're putting forth someone who's only been licensed for 2 days, that's not okay. But it could very well be put in because it is in the practice monitoring one. On page 14, or no, that's not that. Page 13, I know that staff and I had talked about the 12-step program. We could put something to that effect in there. However, it does not work for all respondents. And so what I've seen from other boards and why I did recommend to staff to change that language is that I have seen with my other boards a lot of respondents asking to do different types of support groups. So, and I think you had looked at some research on it as well.
Yeah, I
right?
mean, not, from what I've found and what I've seen, I mean, AA and NA does not work for everybody. And there are some studies that question the effectiveness of the 12-step program, so we just wanted to keep it a little bit more broad, a support group, because there are groups that are non-12-step based that are effective. So we just wanted to have it a little more open for that purpose.
And then it does address the frequency, and that will be determined on a case-by-case basis. So if somebody needs, if the board or its designee feels that somebody needs to go every day, then that would be ordered. If they feel that they need to go once a week, and it could be, and I've seen it where it's once a week for the first 6 months, and then once a month thereafter, or for the duration of probation, things like that. So it would be very case specific, and so that's why the language is a little bit more general to be open to different people's tailoring to their needs. So, and did you I missed the first one about the billing monitoring. Was that just saying that we had put the qualifications in that one to distinguish it from the other one, or was there a specific?
I think it's duration of
also-
practice.
Well,
Page 9.
the issue is qualification, and what is most commonly used was duration of practice. That was, could a newly licensed provider be put in that position? And I would submit that would not be a wise decision, and I don't think the board would do that. I'm just suggesting that it should be explicit, because that would shorten the conversation.
Right, so the board could put that in, or it could lead to the board or its designee to determine that for each and every time. So, I mean, it's, if that, I don't know if that's something that comes up a lot. Is that something that?
We're usually not seeing brand new licensees, but that would be something, that we would not currently allow. But I think it's always nice to just have it in the language so they know we're not doing that back and forth.
Right. The only hesitation I have is that then you just set parameters as to what is a new licensee, how long
Yeah.
is that, what does that include? What may be, I don't know, what may be a new licensee to me may not be a new licensee to you. So that would have to be spelled out.
Could we not just use the same standards as for supervisors of clinics and training programs, whereas 5 years of
You could
disciplined
you could
practice?
Absolutely, yeah.
I think that helps too in general, just to be consistent, so we don't deal with all these changing requirements and standards with every individual paragraph.
So that would then also apply to the,
15.
supervised project. Don't wait for me to get there, just shout it out.
Do we have to go back and revise the motion to adopt those changes as well, or we'll just?
I mean, we can roll it into, you made the motion, would you like to amend it to include the changes?
If it already rolls it in there, not
There was
amending
one of the
anything,
budget.
so, okay.
There
Very
was
good.
one other change that
Sure.
Dr. Gibbon pointed out about the page 13, number 12, licensed practitioner, documentation from licensed practitioner.
medical provider.
Yeah, do we want to change that?
To licensed medical provider.
I mean, yeah, I think practitioner is unnecessarily specific. I don't know what you guys think about that, but I'm okay with that change.
Licensed medical provider?
Yes.
Okay.
I'm not attached. I'm not attached.
Okay. Are we ready for a
That's
vote? Any other public comment? Okay, we're ready for a vote.
Okay, the motion is by Hildy to move to ask staff to make changes discussed here today and delegate the authority to them to make those changes and then to bring it back to the full board at a future board meeting. Is that accurate, Hildy?
That's accurate.
Rad. The second is by Jeannie. The vote is Hildy Alvanado,
Yes.
Francisco Shea, Jeannie Kang,
Yes.
and James Moore.
Yes.
Okay, 4-0, that motion passes.
Thank you very much again. That was an extraordinary amount of work and caused substantial discussion. So I'm looking
Thank
forward
you,
to these
guys. Yeah,
finally being updated at some point.
very good.
Let's move on to agenda item number 3, discussion and possible action on prostitution prevention and condition of office regulatory package. That one goes to Mark.
Okay, this is also a joint, Christine and I have both worked on this issue, so I'll just kind of go over what we're doing. Basically, this was something that we originally wrangled around, and the board passed some language back in 2013 or 2014. Originally, the board had we had desired to have more regulatory authority to discipline licensees who had allowed their places of business to become places of prostitution, but who may not be engaging in sexual acts themselves. What we had sort of found was that sometimes people were sort of taking advantage of that. We wrote skating by the board's regulatory authority. And staff in the AG's office were noticing that criminal charges were being dismissed or plea bargained away when the licensee was the sole owner of the business. This is a regulation that we, when we had reviewed all of our regulations earlier this year, this was one of those things that we had identified as sort of needing probably to be cleaned up and maybe rewritten. And we worked very closely with our Deputy Attorney General liaison in coming up with this language, and feel that it's actually pretty solid language. So the previous, you notice the second attachment is the proposed regulatory language itself. So the first thing we want to point out is that we do have, it was originally the original language was placed into CCR section 1399.450 subsection B. Whereas an acupuncture license is used in connection with any premises, structure, facility, no sexual acts or erotic behavior involving patients, employees, patrons, or customers, including but not necessarily limited to sexual stimulation, masturbation, and prostitution shall be permitted on said premises, structure, or facility. We have struck through that language. We had also mistakenly struck through subsection A of 1399450. We will not be striking that language, obviously. We still want to have the clean and sanitary. So that is an error on our proposed regulatory language. So that will not be struck through. And then Kelsey had pointed out that 1399.469.3, where we have originally located our new regulatory language, that actually is taken up by another, that is actually taken up by the requirements for posting of licensure by the Acupuncture Board, which is a regulation that just went into effect on October 1st. So we are proposing to put it into 1399.469.4. And in addition, you'll notice above there it says adopt new Article 6.5 enforcement, beginning with, we will not be adopting a new article, so we will be removing that from the proposed language. The new language, 1399.469.4, prohibited sexual acts. I guess I'll just read it real fast. Subsection A, Any person subject to regulation by the Acupuncture Board who knowingly engages or aids and abets in by owning, leasing, licensing, or operating a location where sexual acts or attempted sexual acts occur involving any person but not limited to patients, clients, employees, patrons, visitors, or customers, whether or not fees for services are paid, that person shall be guilty of unprofessional conduct. We define sexual acts, subsection B. Sexual acts as defined in this regulation means the touching of any part of a person for the purposes of sexual arousal, gratification, or sexual abuse. Sexual acts included but is not limited to sexual intercourse, masturbation, sexual stimulation, and sexual penetration. And subsection C, the license, certification, or registration of that person shall be subject to denial, suspension, or revocation by the Acupuncture Board. Our authority cited, we cited section 731 and 4955, Business and Professions Code, but actually the authority cited will only be 4955. Reference will be section 731, Business and Professions Code. Okay. So that's the overview.
Can I ask a question about why we're not adopting a new article? Because that was one of the things that our liaison from the AG's office had proposed, because a lot of our enforcement regulations are kind of just stuck under the article of miscellaneous provisions.
No, you can most definitely adopt a new article, but you can't adopt that article.
That particular one, gotcha.
So, just based on the way that the flow of the numbers work.
Right.
So, when I just took a look at it, and so it's not that you can't adopt a new one, you probably should, but it just cannot be 6.5,
Gotcha.
based on the numbering.
I don't have any questions on that issue. Any questions from the board? Okay. Shall we take a motion to?
Sure.
So I would recommend, just because I had caught that adoption thing this morning, that you'd maybe delegate to staff to make that technical change, but then the rest could be.
Is there a peril of defining sexual acts in this particular reg where it could possibly be defined elsewhere and conflict?
So I believe you went with the penal code definitions, didn't you?
Yes.
I think we talked about this one a
Yeah.
long time ago, sorry.
Yeah.
But I think that,
Do we have a benefit in just referencing the penal code as to redefining it on our own, or do you think it's worth just?
If memory serves, he took the definition of sexual acts directly from the PC code, the penal code.
So should we reference like sexual acts as defined by penal code section blah, blah, blah is blah, or should we
I mean,
lay
you
it out?
can, I think that this gives it a little bit more clarity in terms of, just so people know, and it's not an extensive, and it's not an exhaustive list, obviously, it's not limited to. I think you can reference back, but sometimes for your reader, that can create issues of clarity.
Okay.
But.
How are the other boards written in this area? Like the
You know,
chiropractic board?
not a lot of boards, so this is a, it mirrors, the language mirrors a lot what the Business and Professions Code already has in place. But I think the thought process, and correct me if I'm wrong, is that acupuncture just, had some issues with this particular,
Yeah, this is, the only other board that I'm aware of that has sort of prostitution prevention type is chiropractic board. And their regulation was written back in the 70s.
So we're updating.
which was prior to the actual statute. So I can read you the statute quickly if you want to hear what that says, because it does mirror fairly closely
Okay,
what this is.
yes, I would like to hear it.
Any person licensed, certified, registered, or otherwise subject to regulation pursuant to this division who engages in or who aids or abets in a violation of section 266H, 266I, 315, 316, or 318, or subdivision A or B of section 647 of the penal code occurring in the work premises of or work area under the direct professional supervision or control of that person shall be guilty of unprofessional conduct. The license, certification, or registration of that person shall be subject to denial, suspension, or revocation by the appropriate regulatory entity under this division. Subdivision B, actually, so subdivision B just imposes a civil penalty on it that a district attorney can do, so.
So we're just spelling it out a lot more clearly, so there is no further misunderstanding. Okay, so let me just play devil's advocate for a second. I understand that the acupuncture profession had problems with this, and I go both ways on this. On one level, I don't mind the specificity of the language, and on another hand, I'm cautious about it.
I did want to point out one huge difference was the main issue that we're trying to address, because there's already that section 731, that ties it to an actual conviction of the licensee or an employee on that premises for it to be a violation. So a lot of times what we're saying is the act occurring within the arrest and everything, the report that we review, but then it gets pled down and they don't actually get convicted of the section numbers that are referenced in 731. And so then our hands are tied. So what this language does is it identifies the actual acts that identify what the violation is, as opposed to actually being convicted of the penal code sections that are referenced. Yeah, so I just wanted to add that in.
Yeah, no, I understand. It's just unfortunate that this
have
part
to
has
do
to even
it.
add this part, because it's kind of, it's unfortunate, that's all, I'll keep it simple. So if it's necessary for you to do your job better, then, I am gonna have to agree with it.
I would say that previously we saw this problem a lot more. We're seeing it less and less.
Good.
But, there are still those situations that come up, and it does, like you said, kind of closes the loop and covers that.
But Christine, are you able to give some kind of estimation as far as how many of these potential cases are being pled down, or how many of these cases that you see through an enforcement capacity? I mean, I'm sensitive to Jeannie's comment and don't want to give the
Right.
impression that, we
Yeah, like our
see this all the
profession is like,
time.
yeah, exactly,
Um,
that's
Yeah.
my concern.
But
Well, I think you had written in the memo that.
Yeah, it's kind of hard to, it's kind of, our tracking system for enforcement doesn't have sort of specific categories for prostitution.
Right.
But based on sort of the information that we've gathered, it's usually somewhere about 5 a year that we investigate or so, or maybe a little.
Well, I think you had said here, because we had done the research a while back.
Yeah,
The last 5 years.
20 in the last 5 fiscal years.
Yeah,
it's like
so
5 a
yeah,
year, so.
I would say probably around that, maybe less, but it's different year to year, but
Some years-
definitely.
One year it was like 0 cases reported, and then another year it was like 7 or something like that, so.
And
it
then
does-
because of the reporting issues, it could actually be higher, it could actually be lower, so.
But I also think like it's more understood by the public too, that if they're seeing that prostitution is possibly going on at an acupuncture location, that is outside of our jurisdiction at that point. That needs to be reported to, like a vice unit of local law enforcement. Beforehand, I think public didn't understand that. Also, law enforcement, they were used to provide that information to us more so. So I don't know if they're kind of handling it at a local level and not bringing us into it as much. I don't know, but it was more of a problem, I would say, maybe 5 or 6 years ago, whereas it's gone down a lot, but.
Maybe this is something you could talk about in your Haven Trust presentation
Yeah,
as
I
well.
have some stats for that.
Okay. Are we on, what are we on, public comment, board discussion? I'm forgetting now.
Motion.
Motion,
Making and crafting.
we're
Unless
still on the
there's more
motion. Okay,
comments.
is there a motion?
Jeannie was crafting.
I could try it. I motion to approve staff recommended language for CCR section 1399.4693 and direct staff to make technical changes to this language to bring back to the full board.
Second.
Do you want, okay, because are you gonna bring it to the full board today?
No. Greg?
We
Because
didn't,
you'd have to go back, the staff to go back and make all the
Well,
changes.
Well,
the
you
changes are
make
pretty
changes.
minor.
Oh,
yeah.
The
okay,
changes
well, I
are
was trying to
just,
help you guys out.
thank you. The changes are pretty minor. We're just changing where we're putting it
Okay.
and deleting the,
So then,
et cetera, et cetera.
and I think we could actually do that today because this is smaller versus the disciplinary guidelines are, what,
Okay.
14 million pages?
So I'll be more specific.
So you wanna add like that in there to take it to the full board and move that, the full board approve the proposed language with the changes that the committee has made. And then put it out for a 45-day comment period.
So do this.
Yes. The first one.
Okay. I move to approve the proposed regulatory language to section 13999.469.3 and presented and direct.
Point four. We're moving to
Point four, as presented and direct staff to notice the language for public comment without setting a hearing.
Unless you want to hear.
No.
Is it- Okay.
Thank you, Jamie.
Second?
Second. Any more discussion? Any public comment? Wonderful. I think we're ready for a vote.
Yes.
Mark?
The motion has been made by Jamie to approve the staff changes to 1399.469.4
Bring it to the full board.
and bring it to the full board with the changes as specified today.
Approve the proposed regulatory action. It's number one.
Number one approved as amended, or approved as,
Approve the proposed regulatory action,
the language is revised, or it means revised, so it's improved as amended.
but you already covered that.
Okay.
It's covered.
Okay, fair enough, thank you. So many technicalities. Okay, the motion is by Jamie to move to approve the proposed regulatory action to section 1399.469.4 as presented and direct staff to notice the language for public comment without setting a hearing. The second is by.
And for staff to make any technical changes.
Awesome. Second is by Hildy. The vote, Algonado,
Yes.
Francisco Shea,
Yes.
Jeannie Kang,
Yes.
Jamie Zamora.
Yes.
All right. 4-0, the motion is passed.
Wonderful. Thank you very much,
Oh,
Mark.
sorry, we didn't do public comment before you
Oh,
voted.
We did.
We did.
Oh,
We
okay.
did.
Yeah.
Yeah.
Just kidding.
Let's move on to agenda item number 4, future enforcement committee agenda items. I know in the previous committee, Jamie listed out a very long list for the education committee. I'm afraid I don't have one for enforcement. Ben, is there anything, that's all Jamie's fault. Ben, do you have any recommendations for future agenda items?
At the moment, no. We do have our load ahead of us to address a number of these items as they stand, but we will bring the disciplinary guidelines back and the conditions of office back to the board.
There was an issue that I thought was a hybrid between education and enforcement as well, talking about CE provider enforcement. It might, I don't know if that's a committee issue or if we could just discuss that in full board and include the statistics in the full board meeting, but I think we were starting to look at those audits and enforcement mechanisms. But
We
we'll,
could include in education or enforcement.
I think it's more enforcement,
How do you say?
yeah.
so,
Well, I don't know,
okay.
yeah.
We will note that as a
Enforcement.
for enforcement committee.
I'd say it's enforcement.
We'll spread the wealth.
Yeah.
Do we need public comment for that? We don't.
Well, for if they have future enforcement committee
Oh,
items.
Okay. Public comment on the agenda item number 4?
Any future items?
Okay.
Hearing none, let's move on to number 5, public comment for items not on the agenda.
Okay.
Hearing no public comment. Any other board questions before we adjourn? Oh, one more.
Ron Zeidman, President, Five Branches University. Are we going to talk about dry needling during the general meeting or during this enforcement meeting? That's the question.
Dry needling was tabled from the research committee. So it was in the first committee meeting and it was tabled. The discussion was
You
tabled.
can talk
Okay.
about it at the public meeting at the end, comment.
Yeah,
Okay.
you can do public comment there,
Okay.
yeah, absolutely.
Any other public comment? All right, I move to adjourn.